statistics that were read out by the Honorable Justice and the head of the High Court Commercial Division is a testament to this. This is not a courtesy extended to litigants. It is a rule that they can rely on. And in matters of credit and capital, reliability is worth more than a sentiment. The Bank of Uganda came to this fortnight not only as a convener, but as a litigant. In our capacity as a liquidator of the Close Marketed Credit Bank Limited and the EFC Uganda Limited, we brought forward disputes that had, in some instances, outlasted the institutions themselves. We left with 3 consent judgments and a further suite of settlement proposals still under negotiations. Parties who once at the same table could design tailored repayment plans and negotiate interest concessions that no judgment, however sound, would have troubled itself to craft. This is what mediation does, and adjudication cannot. It feeds the outcome to a relationship that, in banking, usually has to continue. So, an exit meeting to be what its name. We must also be honest about what is still resisting us. Colleagues, you all agree that consent judgments still take longer to execute than the mediation that produced them, slowed by layers of internal approvals within our own institutions. Procedures still exist and insist in places of physical appearance where a signature or a video link would serve well. And some borrowers, frankly, still treat mediation as one more delay to be run out rather than the off-ramp from litigation that it is designed to be. None of this is a reason to retreat from ADR. It is a reason to refine it. On our part at the Bank of Uganda, we will continue to ensure that the CEOs participate in this event. We will take whatever it takes to ensure that they do. To that end, I want to propose 4 priorities for the sessions ahead. First, if we're going to have future mediations, which I believe, I think the window should be extended so that we're not constrained by the arithmetic of the diaries. Second, streamline the consent judgment in chambers or electronically so that settlement reached in a mediation room does not lose momentum in a registry. Third, standardize tiered ADR clauses across financial contracts so that mediation becomes the contractual default, not a concession negotiated out of pressure. And last but not least, screen the cases for ADR suitability at the point of filing so that suitable matters are identified before court resources are spent on them and frivolous interlocutory applications are discouraged from the outset. These are just modest asks and deliberately so. Judicial independence and prudential regulation each depend on predictable rules, not on ad hoc goodwill. And the fixed judiciary strategic plan for 2025-2026 to 2029-30 rightly places ADR among the instruments for building that predictability, alongside the sector's own ambition to have the case backlog by the end of the decade. Institutions earn credibility the same way individuals do, by doing and consistently at that what they say they will do. We do not yet have grounds to declare victory. What we have is evidence that the direction is right, and colleagues on both sides of the partnerships are willing to keep walking it. I think the judiciary, the Judicial Training Institute, the Commercial Division Court, and every CEO bank and legal team that treated mediation as more than a formality of this fortnight. I look forward to our discussions this morning, which we have already had, and to the sessions that are going to follow next. I thank you all for your kind attention, and the good Lord bless you.
Thank you so much, my brother.